I'm Professor Seth C. Oranburg, and today we're diving into the doctrines of estoppel and ratification in the context of agency law. These doctrines play a critical role in defining the boundaries of authority and liability between principals, agents, and third parties. While they share some similarities, each doctrine has distinct applications and implications that we need to unpack. Let's begin with estoppel. Estoppel comes into play when a principal's conduct leads a third party to reasonably believe that an agent has authority to act, even if that authority doesn't exist. If the third party reasonably relies on this belief to their detriment, the principal could be prevented, or estopped, from denying the agent's authority. Estoppel is a type of claim preclusion, and it protects third parties from unfair outcomes by preventing the principal from making the claim that the agent was unauthorized. This protects third parties from unfair outcomes when they've reasonably relied on the principal's representations or actions. Here's a simple example. Imagine a business owner frequently allows an employee to negotiate contracts on their behalf, even though the employee isn't formally authorized to do so. Over time, third parties come to believe that the employee has authority to act for the business. If the business owner later tries to deny that authority after the employee enters into a contract, the doctrine of estoppel might prevent the owner from making this claim. The reason is that the business owner's own conduct, allowing the employee to act in this way, creates a reasonable belief for the third party. By the way, this is related to the concept of apparent authority, and historically the doctrines were more separate, but now they've been integrated to a certain extent by the third restatement of agency. Now, let's contrast estoppel with the doctrine of ratification. Ratification occurs when a principal affirms or adopts the actions of an agent after the fact. Unlike estoppel, which focuses on the third party's reliance, ratification depends on the principal's subsequent approval of the agent's previously unauthorized actions. When a principal ratifies an agent's actions, it's as if the principal had authorized those actions from the outset. Ratification relates back. To illustrate, let's say an agent enters into a contract without authority to do so. The principal learns about the contract and, instead of rejecting it, decides to accept its benefits or explicitly approves the deal. By doing so, the principal has ratified the agent's actions. This makes the contract binding. This can happen even if the agent didn't initially have actual or apparent authority, as long as the principal's ratification is knowing and voluntary. The Restatement Third of Agency offers valuable guidance on these doctrines. Estoppel is addressed in Section 2.05, which emphasizes the importance of the principal's conduct in creating reasonable reliance. Ratification, on the other hand, is covered in Section 4.01 through 4.03, which detail the conditions under which a principal's acceptance of an agent's action binds them to those actions. While these doctrines differ in focus, they arise in similar situations where there's ambiguity around an agent's authority. For example, consider a situation where an agent negotiates a contract without authority, and the third party reasonably believes the agent is authorized. If the principal's conduct created that belief, estoppel might apply. But if the principal later chooses to approve the contract, ratification would govern the outcome instead. So in some cases, these doctrines overlap, and courts may analyze both to determine liability. One practical takeaway from principles is the importance of clear communication and control over agents. To avoid disputes over estoppel or ratification, principals should ensure that third parties understand the scope of an agent's authority. For example, if an agent's role changes, or if their authority is revoked, notifying relevant parties promptly can help prevent misunderstandings. Similarly, principals should carefully evaluate unauthorized actions before deciding whether to ratify them, as ratification creates binding obligations. For third parties, the key is to exercise reasonable diligence. Before relying on an agent's authority, it's wise to confirm the scope of that authority directly with the principal whenever possible. This reduces the risk of disputes and ensures that agreements are enforceable. In closing, it's important to note that estoppel protects third parties who reasonably rely on a principal's conduct. while ratification focuses on the principal's voluntary approval of an agent's unauthorized actions. Both doctrines balance fairness and accountability, ensuring that principals and agents act responsibly in their dealings with others. In our next lecture, we'll wrap up and review the big picture regarding agency law. Until then, you might think about examples where someone acted on behalf of another without clear authority. What factors would determine whether estoppel or ratification might apply? Did the principal, although surprised by the results, later agree to accept the benefits? That's an example of a ratification. Thanks for listening, and I'll see you next time.